region by the Igbo-Biafra Nationalists and the indigenous people of Igbo Nation for self-determination from Nigeria is multifarious, encompassing historical, legal, political, and human rights perspectives. Let's examine each point in detail.
Number 1. The notion that Southeast region or the Igbo-Biafrans have a historical claim to independence is rooted in the pre-colonial existence of distinct ethnic groups and entities in the area now known as Nigeria. The amalgamation of these diverse groups by colonial powers did not necessarily reflect the consent or the distinct identities of these groups. The Southeast, or the Igbo-Biafra's claim, hinges on the argument that its historical identity and socio-political autonomy were compromised in the formation of modern Nigeria. Number 2. The argument intensifies with the assertion of gross human rights violations against the Southeast, the Igbo-Biafrans. International law recognizes the right to self-determination, especially in contexts where a particular group is subject to severe oppression and rights abuses. The systematic violations against Biafrans, especially during the Nigerian Civil War, could be construed as justifying secession under international law as a form of remedial action. 3. The consistent discrimination against and failure to adequately represent the Southeast zone or region, who are the Igbo-Biafrans, by the Nigerian government forms another critical pillar of the argument. This lack of representation, coupled with systemic discrimination, fuels the contention that the Southeast has a legitimate claim to seek self-governance. 4. The Southeast's involvement in the 2014 National Conference and the subsequent disregard of its outcomes by the Nigerian government highlight a perceived institutional unwillingness to address the imbalances and grievances of the Southeast zone or the Igbo-Biafra region. This strengthens the argument that internal political remedies have been exhausted, thereby necessitating secession as a last resort. 5. The Nigerian government's dismissal of the Ohaneze Ndigbo's petition to the Oputa panel aimed at addressing historical grievances underscores a broader pattern of ignoring the concerns of the Southeasterners or the Igbo-Biafran people. This rejection is a failure of the state to engage in meaningful reconciliation and address the roots of the conflict. 6. The alteration of Nigeria's administrative and political structures without the consensus described in the 1970 Instrument of Surrender arguably constitutes a breach of an agreement that was critical to the Biafrans' decision to cease hostilities and reintegrate into Nigeria. This breach is a direct undermining of the legitimacy of Nigeria's governance over the region. The Nigerian state has violated the terms of the Instrument of Surrender of the Biafrans in 1970 that any further change in the structure of Nigeria must be agreed. The Biafran Chief Justice, late Sir Louis Mbanefo, insisted on inserting Clause C of the Surrender Instrument, which, after accepting the existing administrative and political structures, which were the then 12 states, says that any future constitutional arrangement will be worked out by the representatives of the Nigerian people. 6 years later, in 1976, General Murtala Mohammed and General Olusegun Obasanjo unilaterally increased the number of states to 19. General Babangida added his, and General Abacha brought the number to 36. Read more of this from Chudi Ofodeli's seminal book on the future of Nigeria, launched in 2017. 7. The Southeast Igbo-Biafra case is a unique sui generis due to the entrenched and systematic nature of discrimination and marginalization by the Nigerian state. The deliberate, intentional, consistent policies that seemingly target the Southeasterners for unequal treatment is a state-sponsored apartheid, exceeding the threshold of oppression and thereby justifying secession as a remedial measure if the Southeast Igbo-Biafrans are willing and able to do so. The brutal Nigerian military oppressions often being carried out and targeted at the self-determination groups, and especially the youths who represent the future and the hope in the Southeast zone or region, constitute ethnic cleansing and is genocidal, with the sole intention and purpose to depopulate Southeast and gradually exterminate the Igbo population. To the contrary, the security exercise of the security forces in other regions is carried out to combat general criminal activities and terrorism, of which the perpetrators are often treated humanely and rehabilitated. In conclusion, the argument for the Igbo-Biafra region's secession from Nigeria is grounded in a combination of historical claims, human rights violations, systemic discrimination, and political grievances. This complex rationale presents a compelling case under international law for considering secession as a legitimate response to prolonged and unresolved injustice. However, it is essential to recognize that the application of these principles can be contentious in the realm of international relations and law. Uche Mefo is the convener of the Igbo-Biafra Nationalists and the indigenous people of Igbo Nation for Self-Determination. Thank you for listening.